So next we have session 4, intersections, ethical and disciplinary considerations for the bench and bar in wrongful conviction cases. And we have Joe Caliguiri, is that pronouncing it right? Caliguiri, Chief Assistant Disciplinary Counsel, Office of the Disciplinary Counsel in Columbus. So thank you very much for coming today. All right.
How's everyone doing today? Good? Doesn't sound good. Come on. So, who here knows who Marv Levy is? All right, one person? Jeez. Football coach, right? All right, anybody remember what team? All right, that's good. I'm a Buffalonian, so I'll apologize for that in a minute. But Marv Levy was a coach of the Buffalo Bills. He took the team to 4 straight Super Bowls. And he was a historian, so William and Mary grad, and he loved to invoke history and quotations. And one of his famous quotes that he'll be remembered for was he would say on the morning of the Super Bowl, so again, he went to 4 straight Super Bowls. He lost all 4, but that's beside the point. He would say, "Where would you rather be than right here, right now?" And then the whole team would yell, "Right here, right now." And it was like this huge uplifting event. Now, my sense is if I yelled that right now, that you might not all in unison say you'd rather be right here, right now. But my promise to you today, for the next 90 minutes, is that I am going to try to engage you and make this interesting, because I find the topic to be extremely interesting. But it's only, these presentations for 90 minutes, they're only good if you guys help me out and interact. Because I have my thoughts and my opinions, but what I'm looking for too are your thoughts. You may have more relevant issues because you may be on the front lines of these types of cases, and you may see things that we don't see in the Office of Disciplinary Counsel for a variety of reasons, some of which we'll get into today. So feel free to interrupt me at any time and share your experiences, your opinions, and we'll see if we can have as much fun as watching a Super Bowl. All right, anyway, as Mark said, I'm Joe Caliguiri. I'm the Chief Assistant Disciplinary Counsel in Columbus, Ohio, and I have been in that office for 17 years. And you know you're getting old when you print out your PowerPoint slides and you're like, oh my God, I can't read this. I hope they have a television screen in front. So I've been there a while. It's a great job. And unfortunately, we don't see a lot of what you see in disciplinary cases. You don't see a lot of cases where lawyers or judges are disciplined for the type of work that you do or undertake. So whenever we're talking about wrongful conviction cases, and this may be my own stereotype or bias, the first thing I think about are prosecutors, right? It's just kind of a split-second thought. But when I started preparing for this, I started to dig a little bit more and try and figure out, well, you know, is it just a matter of prosecutors? And I think all of you know that it's a systemic problem. And everybody plays a part when the system breaks down a bit. So we're going to talk about prosecutors, and we're going to talk about some cases involving prosecutors that we've experienced in our office and some outside of our office. So let's get started, and we'll talk about Rule 3.8. So our rules of professional conduct have some checks and balances in place for prosecutors, all right? Special duties apply to prosecutors. And when we look at this rule, it's basically modeled after the Brady rule, okay? In a criminal case, the prosecutor shall not do any of the following: fail to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense. And in connection with sentencing, fail to disclose the defense all unprivileged, mitigating information known to the prosecutor, except when the prosecutor is relieved of this responsibility by an order of the tribunal, all right? We've all seen that rule. We're all familiar with that rule. Every state in the nation has some form of this rule. Some have additional responsibilities than Ohio does. Some have less. Now, what I find to be the most important part of the rule is not part of the rule itself. it's the first comment to the rule, and it's the first line in the comment. And that is, a prosecutor has the responsibility of a minister of justice, and not simply that of an advocate. And that's really important, and I think one of the things in preparing for this talk that I came across was that there tends to be a mentality across prosecutors' offices that, and it depends on the office, but that we have to obtain a conviction. Our job is to convict. When in reality, since for a long time, it's been understood through all the state's rules of professional conduct that that's not the purpose, okay? Do we have any elected prosecutors in the room? All right, well, for elected prosecutors, what do they run on? Tough on crime, okay? Tough on crime. That's what you're going to hear all the time. Why? Well, because that's what the base wants to hear. That's what the voters want to hear. All right, so you walk in the door with an expectation that you're going to be tough on crime, okay? You don't hear in campaigns that I'm going to be fair, that I'm going to look at all the evidence before I decide to charge a case. And we're not going to go forward unless we're confident in our ability, in our understanding that this person committed the crime. You're not going to get elected. So there's a lot of pressure on prosecutors to go into the job with that mentality. Okay. So let's take a look at the first example. If you don't mind, I'm going to switch this a little because, again, I can't even see the screen. My eyes are getting so bad. All right, so I'm going to look a little bit up. Let's take this fact pattern here. The defendant was a young defendant, 20 years old. He ran a stop sign, struck another vehicle, and instantly killed the driver of the other vehicle. The defendant came out unscathed. He was indicted for aggravated vehicular homicide. Okay, this was an Ohio case. He ended up posting bail on the case. And then, oh, thank you very much. Appreciate it. Oh, look at that. Great, thank you. Then about 6 months later, he got picked up for trafficking in drugs, and he was indicted on that case. That was a lower level felony case that he was indicted on, and bail was set at $1,000, right, which is a reasonable amount of bail. But the defendant was indigent and couldn't afford bail and ended up sitting in jail awaiting trial now on both cases, quite as would be the case. Now, during this case, he was represented by a public defender. And the public defender was representing him on both the drug case and the murder case. And so the state basically gave a plea offer. The first plea offer was rejected out of hand. The state came back a little bit later after another pretrial conference as the trial was approaching. And they offered him 6 years for the aggravated vehicular homicide and the trafficking in drugs. And they talked to the defense attorney at length about the plea, and the defense attorney said, let me consult with my client, and I'll let you know what we're going to do. So the defense attorney goes and he consults with his client, and he takes about a half hour or so, and they go through the ramifications of what this means. And the defendant had a small child, an infant child, and he was concerned about the length of time, obviously, that he would be doing in prison. And so he decided to reject that plea offer, okay? So the defense attorney goes back to the prosecutor and says, my guy's not interested. It's too much time. He's got a defense to this thing. This was a traffic accident. You don't have that strong of a case here. He feels like he's got a good shot. The trafficking in drugs might be another story, but 6 years is just too much, okay? So prosecutor says, okay, well, we're going to start prepping for trial, which was in the next 5 or 6 days. All right. So just a few days before trial, the prosecutors on the case interviewed the defendant's mother, because part of the defendant's story was that he was on his way to his mother's house to pick up his infant son. The accident occurred at like 4 or 5 in the morning. And he had also made some statements to the police, though, that he had been out, and they were inconsistent, that he had been out the night before and that he had been drinking and smoked marijuana and things like that. So the prosecution's theory was that this guy was high when this happened, blew off the stop sign, killed this person. He was saying he was getting up early to go pick up his infant child at his mother's house. So there was, definitely an inconsistent story. But at any rate, they wanted to find out from the mother whether or not, in fact, the defendant was on his way to pick up the child and whether the child was staying with the mother. So they interviewed the mother for quite some time. Now, interestingly, in this case, the prosecutors, and these were two prosecutors that were interviewing the mother, both of these prosecutors had prosecuted her other son and convicted the other son of murder years earlier. All right. So in a sense, they knew this person to some extent. And she had felt, the mother, that they had given her son a fair shake in that other case. She didn't really hold any bias against that prosecutor's office for that. So during the interview, the factual interview, they start telling the mother that, hey, your son, the current one that's in with the vehicular homicide, he made incriminating statements. Do you know that he said he was out drinking the night before and that he was smoking marijuana? And they could tell that at that point in time, this was probably the first time the mother had been hearing this type of thing. And so the mother started to get a bit distraught. And they were basically saying, look, you already have one son in prison. This guy's going to be going away. The best thing to do is for him to be able to mitigate how much time he's going to get here. And, we're offering 6 years, but your defense lawyer is getting in the way of things. And they kind of take some jabs, make some snide remarks about the defense lawyer, okay? And of course, the defense lawyer is nowhere to be seen in this meeting here. So, the mother starts to think about it, and she says, well, this is crazy. You guys have been fair to me, and, that sounds like a pretty good deal if he said all those things. And they say, well, we already gave the plea to the defense attorney, and, your son's rejected it. So now we don't know exactly what went down in that meeting, but what ended up happening was the prosecutors called one of their victim advocates in, and they sent the victim advocate over to the jail with the mother. And they said, talk to your son about the plea. Now, the victim advocate went over there just because it was kind of a maze to get over to the jail. And so they wanted somebody to show her how to get there. So they walk her over there. On the way there, the victim advocate says to the mother, hey, I overheard a little bit of the conversation you were having with the prosecutors here. And they told you that your son would face 11 years in prison. She said, I'm pretty sure if he got convicted, it'd only be 9.5, which actually turned out to be true. Okay? So she said, I just wanted to let you know that. I think they were mistaken on the 11 years. So the mother says, okay. So the mother goes into the jail, and they have this meeting. Okay? And she meets with her son at that point. The son says, Mom, I already rejected that offer. They just gave me that offer a few days ago at the pretrial, 6 years. My lawyer told him, no, I'm not doing that. I shouldn't have to do 6 years. This was an accident. So the mother says, well, they're telling me this. You never told me that. I think this is a good deal. You saw what happened to your brother. This isn't going to end well. You should really think about it. And they have this long conversation, okay? And then what ends up happening is the defendant says to his mother, you know what? I would consider doing 2 to 3 years, but that's it. I got the young son. I want to get out, okay? So the mother says, well, I don't know. They told me 6 years, and I'm not really sure, okay? So the mother gets back in touch with the prosecutor, goes back and meets with them, and the prosecutors say, no can do. We can't do 2 to 3 years, but I'll tell you what we'll do. We'll give you 5 years. We'll give your son 5 years. He'll be eligible for judicial release in 6 months, but we're going to oppose that, but it's up to the judge, okay? So now the mother starts saying, my son said 2 to 3 years, I don't really know. He said, well, why don't you go back, talk to your son again, give him the new offer to 5 years with potential for judicial release after 6 months, even though we're going to oppose it, okay? And by the way, here's my cell phone number. I want you to call me after you talk to your son and let me know what he says. And if he says yes, then I want your son to call his lawyer, and I want him to tell the lawyer that he's got a new deal that the son wants to propose to the lawyer to go back to the prosecutor. Anybody seeing a problem here yet? Okay. So lo and behold, mother goes back. Defendant says 5 years, potential getting out after 6 months. All right, I'll take that deal. Okay? So sure enough, as instructed, the defendant, through his mother, in the jail, calls his lawyer and says, hey, I want you to go to the prosecutors, and I want you to offer this, I want you to ask if they would consider 5 years with a potential for judicial release, and I want to be out until my plea. I want to get out of jail until my plea. So that wasn't part of the plea deal, but that's what he proposed. So the defense lawyer says, what do you think the defense lawyer says? Yeah, I'll do it, but it's not going to happen. Okay? We just had this discussion 2 days ago. They're adamant they're going to trial on this case. But the defense attorney does what he's supposed to do, and he calls up the prosecutor. Prosecutor answers the phone and says, hey, my client's proposing this deal. What do you think? And the prosecutor says, oh, well, let me think about it. Okay, well, all right, we'll do that. I think we can live with those conditions. And they arrange for the defendant to be brought over to court that afternoon. He pleads guilty. And during that particular plea colloquy, okay, there is some discussion about this judicial release after 6 months. And the defense attorney says, I don't know where you're getting this judicial release for, but, you're not getting judicial release. You're not eligible for judicial release. And the defendant says, I'm willing to go forward with what I got to do here. So we got a failure to communicate here. All right, between whom? Who's our failure to communicate between? Prosecutor and defense, right? Isn't that the way the system's supposed to work? Okay, but that's not what happened. Plea goes down. Defendant gets released as promised, okay, until sentencing. A few days later, the mother's talking to the defense attorney about some logistics and stuff, and she talks about this conversation she had with the prosecutor. And how many people are defense attorneys in here? All right, what's your reaction?
I died a long time ago.
You're already dead, yeah. You're like, what? Wait, whoa, what are you talking about? Now, what do you think was the defense attorney's initial reaction? Spontaneous. Pissed, yes. But what else? It might surprise you.
That's a good deal.
No? Although he did eventually say that he felt a little bit ashamed that he couldn't work out that deal, right? But which you would think, But what else? It kind of surprised me. I'm going to give you a second to chew on it, just because I think it's interesting.
Do you think it was decent of them to talk to the mother?
I'm sorry?
I think it was decent of them to talk to the mother.
All right. That's interesting. Decent to talk to the mother. That's interesting. We're going to come back to that.
Didn't believe the mother?
Didn't believe the mother. Okay? Didn't believe the mother. And I think it's interesting because if the system was working properly, that's probably the appropriate reaction, right? You wouldn't believe the mother because you're thinking, well, they're prosecutors. They're ministers of justice. They're not going to do this. For what? Right? So I thought that reaction was really interesting. But anyway, the mother persisted. And so basically what ended up happening was the defense attorney called the prosecutor on the phone and said, I got this guy's mother in here telling me that you guys worked out this deal behind my back. And the prosecutor said, yeah. And your point is? And of course, then the whole situation blew up, and the prosecutor was really offended. I'm sorry, the defense attorney was really offended by that fact that this prosecutor would do an end around to get to his client. All right. Now, what's the dilemma the defense attorney's in right now? Because you see the next thing. It's not a bad deal. He got a good deal. So whose interest are we concerned about here? The prosecutors, the defense attorneys, or the clients? Right? So you got a defense attorney who's royally pissed, and rightly so. You got the prosecutors who are saying, we gave the guy a really good deal. How could you be mad at us? You got more than what, we gave him more than what you were bargaining for. And then you got the client. And the client's sitting there thinking, okay, I don't really care how this went down. All I know is I'm out, and I'm out right now. And the attorney says, well, let me tell you what the issues are here. And I think that you may have grounds to withdraw your plea because there was an impact on your right to counsel. They went behind my back. They weren't advising you through me. And so I think you have a basis to withdraw your plea. Okay? Well, what does that mean for the client? You're back to square one, right? But the client decides, and the lawyer did a really good job of laying out all the options, and he told them, there's nothing wrong with you taking what you have here. You could do it. But the client decided, no, I'm not going to do this. Okay, I'm going to move to withdraw my plea. Okay? And the prosecutor's basis was that this person was coerced. They took advantage of the mother, who was in a vulnerable state. You know, she had one son in prison for murder, another son facing aggravated vehicular homicide. They got to her, she got to him, and here we are. And so the court grants the motion. So then after they grant the motion, they get into some plea negotiations, and the state comes down and they offer 4 years. And they say, you're not going to be eligible now for judicial release until after 4 years anyway, that there was a mistake before. And the defendant now at this point says, you know what, I'm not doing this. I don't think I did anything wrong on the traffic case. And he ends up actually pleading guilty on the drug trafficking case on a later date. And he goes to trial on the vehicular manslaughter, and he gets convicted, and he gets 8 years. Okay? So why? Why would a prosecutor, two prosecutors, by the way, why would they do this? Now, these are just some examples or theories that I've come up with, okay? You hear this one a lot. This defense counsel is a pain in my ass. You know, I knew if we had somebody else on this case, this would be a done deal. Okay? How many are that defense attorney? Now, you're going to fight till it's over, right? Okay? Trial fatigue. Now, during this time, there was some testimony that the prosecutors had some back-to-back trials and things like that, and was kind of tired. All right? A human element. Now, I said there were two prosecutors. Think about this for a second. The two prosecutors on the case were the elected prosecutor and his chief assistant. All right, so the top two people in the office are going down this road on this case. So if your boss is leading the charge on this, the chief assistant is really in a tough spot, right? I mean, all of us think that we would be the ones to stand up and say, whoa, hey, boss, you know, why are we doing this? If we have to go to trial, we have to go to trial. Or we can lower the plea. But it's not that easy when your boss is saying, this is what we're going to do. Okay? Now, they brought in the other person. Remember the victim advocate? So think about that for a second. You got the elected prosecutor, the chief assistant, calling up the victim advocate and saying, walk this person over there and make sure that after she talks to her son, she calls us back. Oh, and by the way, she heard half the conversation because she knew enough that they had given wrong information on how much time the defendant was facing. So now you have a non-lawyer staff member of the office that is aware of how they do things in that office. And that person could either accept it, reject it, not think anything of it. But what they probably did was what anybody would do, go back and tell their coworkers, right? This is what just happened. And eventually, you get a culture where it's okay. You know why? Because we put a guilty person behind bars. And that's okay. And that becomes the culture. So that's why I put shadow of the leader. If the boss is doing it, and they cast a wide shadow, it's really hard for the underlings in the office to do things differently. Okay? And it's in this case, it wasn't the case, but the chief assistant had been there a long time. But if this was a first or second year lawyer, you're not saying anything. It's just not going to happen. It's a rare breed where that would where someone would do that. And then the mentality, the win at all cost mentality. All right. I personally think that that's what this was about. You have a victim's family, you have a culture, and the culture is we obtain convictions. That's what we're here to do. Okay? So, if you think about this from what the impact is, it goes beyond, this was in a small county too. It goes beyond just the immediate impact on the administration of justice in that case, although there certainly was one. You had somebody that had an offer of, basically pled to an offer of 5 years, got a better offer of 4 years, and ends up doing 8 years, plus the 18 months on the trafficking. But it reinforces that mentality that we're here to win. And I think that that's one of the biggest downfalls of our system in a lot of prosecutors' offices, is that the mentality almost from day one is we're here to win because I just spent 6 months campaigning that I'm tough on crime. So I have to live up to that reputation now. And then, of course, it just reflects really poorly on our system of justice in general. How many people have heard of this case? Oh, one. All right, good. One person. I wasn't expecting any, but I'm glad you did. So, yeah, it does impact the system of justice, but how much? We don't even know about it. And this, I mean, we would all agree that this is pretty severe conduct, right? That this stuff happens. Then, in addition, it obliterates the trust between the lawyers. I mean, the system's not supposed to work this way. How many people have a relationship with a prosecutor in your jobs where they know what you say is gold, and they can rely on what you say without having to do that extra step of due diligence that they might have to do with another lawyer? Okay. And so several of you. Right? Isn't that really the way the system's supposed to work? You know, you're going to fight for your client when you have to fight for your client. When you don't have to fight and it's not affecting your client's rights, the system works best when there's mutual trust between the offices. Okay. How many people have a relationship where they trust the prosecutor implicitly? Okay. Some of the same people, okay? Which is great. That's how you want to, that's how the system should function. If there's a problem in the case, you're going to know about it. Doesn't necessarily mean it's going to get dismissed or not tried, but you're going to know about it. Okay? But I think one of the real travesties here was that what happened to the defense attorney was going to result in a much bigger problem between those two offices. Because you're going to have your counsel's back, your lawyers, your colleagues' back. And a prosecutor that's willing to do that to one of our own is doing that to everyone. All right, so that then affects the whole system. So it really could get magnified in a hurry, okay? All right, let's take it. This is similar. You can play that, yeah. and I'll let you know when to stop it. Thank you. See if we get some sound on this one.
But that office's win at all costs culture resulted in some serious mistakes. As it turns out, fully a quarter of the men sentenced to death during Connick's tenure had their convictions overturned because of improperly withheld evidence. And remember that little electric chair one of the prosecutors had on his desk? Here's a fun fact.
In the photo of Jim Williams with the electric chair, of the 5 faces visible, all of them were released from death row.
Yup. The thing he kept as a token of his success is now a monument to poor decision-making. It is the prosecutorial equivalent of Cuba Gooding Jr.'s Oscar. And look, if you want to see... Why did that joke upset you more than anything else tonight? You have got to be consistent. You've got to be. You might care...
Okay, so that's the mentality that you have in some offices. All right, a prosecutor with a little replica of the electric chair on his desk. You know, that happens. And as people are executed or found to have committed murder, subject to the death penalty, sentenced to death, he puts a little figurine of the person in the chair. Okay? That's not a second-year prosecutor in the office. That's somebody that's high up in the ranks. That's someone where the elected prosecutor walks by every day and pats that person on the back for the great job they're doing in obtaining these convictions. That's setting up the culture in the office. That's teaching the younger lawyers, this is how we do things. You want to get recognized? Follow this guy. All right, and that's how you start to see some of the problems with turning over evidence, because winning becomes more important than the truth. All right? Now, this is my own little story. And I was telling Mark, I was reading his book, which is phenomenal, and I started thinking about some of the things that happened to me in my career. And I was a former criminal prosecutor in Buffalo, New York. And the way our office was set up is we would start out in some what we would call justice courts, which might be considered smaller populated municipal courts, or like a mayor's court. Sometimes we would have non-lawyer judges. I remember one time way out in the sticks, we had this one judge, and he was a farmer, and he would literally come in off the tractor in mud and everything, and he would sit down in a barn, which was beautiful, but they made it into this part-time courthouse. And the only cases we ever got there were like truckers for not taking their breaks, not recording their log books and things like that. It was speeding tickets. And he used to sit down and he'd look over and he'd say, all right, what do we do now, to the prosecutor, And of course, at the time, I really didn't think much about it. It's amazing how much we didn't know. But after you did your stint in the justice courts, you would go into Buffalo City Court, which was a high-volume municipal court, probably similar to what we have here in Cleveland. And that's where it was just, high volume. You get to court, you got a stack of files like this. You just try and get through the day, and you do the best you can. And it's just baptism by fire. So I did like a year in the justice courts, and then I went to the city court. And I'm in there, and I get this case, and it was a criminal trespass, okay? And the defendant was an African-American guy, and he was about 40 years old. And he was charged with trespassing in the subway system in Buffalo, which was brand new, by the way, at that time. And half of it was underground, and then after about half the stops, it comes up above ground in downtown Buffalo. And he was charged with trespassing on the underneath portion of it. So I look at it, and what we were taught to do is, you look at your case, and it's the first time I'm seeing it. I'm flipping through, and you go right to the record. All right, you want to see what you're dealing with here. And so I see that this guy had a robbery conviction for which he served 20 years in prison, and he had just gotten out. Okay? So, of course, that's a red flag for us. So, but then I'm reading the charge, and I'm going, trespassing on the subway? Like, okay. So I go over to the defense attorney and I said, I'll offer you a disorderly conduct, which is lower than, in New York, is like lower than a minor misdemeanor, you know. And he says, okay. So he goes, let me talk to my guy. So he goes and talks to his guy who was, you know, right here. Okay, so it's me, it's the defense attorney, and it's the client. And I said, so I can hear the conversation, you know, because there's just 100 other people waiting their turns as well. And the guy goes, no, I'm not taking that. And his lawyer's like, well, you know, it's a disorderly conduct, and, you know, you're going to walk out of here today. He's like, no, I'm not taking it. He's like, I just did 20 years. I'm not taking a disorder. I didn't do anything. And he's like, I mean, I could ride the subway just like anybody else. And they're having this discussion. And, you know, I'm at that point in time like, you know, whatever. We'll worry about it another day. So the lawyer says, no, he doesn't want it. I said, okay, well, we'll set it down for trial. And then the way it worked is that you would have a pretrial and then a trial. So we set it down for the next case would be a pretrial. So the defendant says, you know, get the video, you know, and he's talking to me. And so I don't say anything because, you know, he needs to communicate through his lawyer. So after the day was over, I talked to the defense attorney and, you know, not even about that case. And he says, hey, you going to get that video? And I was like, what video? And he's like, remember the robbery case where you offered the disorderly conduct? And he's like, yeah, my guy really wants you to get this video. I'm like, yeah, I'll check it out. So I go back to my office, and someday I call up it was the NFTA police, the Frontier Transit Authority. And I said, hey, you know, are there videos down there, this trespass? And they said, yeah, you know, and there's videos. So I subpoena the video, which I thought for a city prosecutor was pretty good, you know, since you don't have any time to do anything. So I subpoenaed the video, and I actually had our investigator go out and take a picture of the no trespassing signs that are out, which actually were visible, plainly visible down there. So I get that, and I'm thinking, all right. And the defendant's issue in the case was he didn't want to plead it to anything because he was afraid he was going to get a parole violation, which is understandable, okay? But I was kind of thinking, well, disorderly conduct's probably not going to get you a parole violation, but you never know. I mean, it's not my life. So, and I didn't even if I put that much thought into it, it would have been a lot at the time. So I get the pictures and I get the video, all right? And the video is grainy, but clear enough to see exactly what was going on. And in Buffalo, in the subway system, what you did was you go in, and there was a machine to take your money, and it would spit out a token. And then you take the token, and you put the token in, and it spits out a ticket. Like, why they didn't just use tokens, I don't know. But at any rate, so the video shows this guy, and he was standing there. And this woman comes up who was, if not 80, maybe 85 years old. Difficulty walking. She gets through, and she can't figure out how to put her money in the machine. You can see her fumbling to get the dollar bill into the machine, okay? This guy comes over, and he's talking to her there's no sound. He's talking to her for several seconds, and he ends up taking her $1 bill, and he's like, you know, straightening the thing out, and he puts it in. The token comes out, he puts it back in, and he gets the ticket, and he gives it to the woman, and then he like turns her around and walks her towards where the train is. And I'm thinking, are you kidding me? Like, I got to prosecute this case? So I go back to my boss after I watch the video. And I say, I just watched this video, and this, you know, I mean, did he ride the subway? I don't know, but, you know, he obviously got arrested for being down there. But the guy's helping an old lady try and get her money, her token to ride the train. And he goes, well, offer him a disorderly conduct. And I said, I already did that. He said no because he's afraid he's going to get violated. He's like, well, what's his record? And I said, oh, you know, he just did a stint for robbery. It was like 20 years the guy was in prison. He's like, robbery, you know, first-degree robbery? And he's like, no, you know, screw him. If he's not going to take the disorderly conduct, we'll take it to trial. And I'm thinking, really? Okay. So in our office, we had a whiteboard. When you walked in, it was all the way at the end of the hall. And that number was on it. What is that? Wins and losses in what? What kind of trials? Jury. Because there's a big emphasis on you had to win jury trials. Okay? Now, I admit, at the time, I didn't really think anything of it. I mean, it's not until I started thinking back about this stuff that it dawned on me how kind of weird it was. So my boss, he was a good lawyer. He was a good prosecutor, and I never doubted his sincerity, but he was big on this jury trial. And what it ended up being was that he was evaluated on whether or not they obtained convictions in jury trials as well. All right, so that was his thing. We're 17-0. So I go back at the pretrial and I tell the guy, I got the video, which I, of course, gave to the defense attorney. And I said, if he's not going to take the disorderly conduct, we got to try this thing. And he's like, you're kidding. And I'm like, no, my boss said we got to try it. And he's like, well, do you mind if I talk to your boss? Like, this is kind of ridiculous. And I said, no. So he did, and my boss threw him out. We're going forward on this case. And so 2 weeks go by, and it comes up for a jury trial. And we go in, and, the tape has to get played. And so I'm pretty confident this thing's going to result in an acquittal. And so we go out. The jury was out for 5 minutes. What do you think? How many say guilty? How many say not guilty? All right, so yeah, jury got it right. So, oh my God, did I not live that thing down? To be the first one to lose a jury trial on a case that, did we meet the elements? Yes, because the officers came in and they said the guy was there. They told him to leave. They came back later. He didn't leave. He was still standing by the same machine. But the jury kind of saw through it, I think. And we didn't poll the jury or anything like that. It was what it was. But I kind of felt they just felt sorry for this guy, And of course, there was no testimony of, the robbery conviction, as there shouldn't have been. But I was the first one to lose a jury trial under that bureau chief's tenure. And so, again, at the time, I never thought about it from a defendant's perspective. I just thought about it like I'm the first one that lost a jury trial. I remember thinking like to me it was more of a waste of resources. Like we're going to call on a jury for this case than it was thinking about the human element of this case and, why this person was so adamant about it. And, do we really want to violate someone's parole when they're in a public place, hanging out and not really causing any trouble, in fact, helping people? So I struggled with it a bit, but I didn't really, it just didn't register because that wasn't the culture in our office. If I would have gone up to my boss and he would have been like, let's dump the thing, just dismiss it. I think that would have changed the way I viewed my job as a prosecutor. And I just didn't know enough at that time to even really entertain all those thoughts. For me, it was just kind of an expediency, resource type thing. So in a lot of prosecutors' offices, I think this is kind of the norm. You're expected to do your job, you're expected to obtain convictions, and you don't ask questions. That's all it is. All right, how many recognize this picture? I was thinking you might, but if you do, don't. Does anyone know? All right, oh, good. All right, if I were to tell you that the person on the right is a criminal defense attorney and the person sitting down on the left is his client, describe this picture for me. What do you see? What are you thinking? Like, what's the lawyer thinking? What just happened? Something good? All right. You're shaking you got some shaking their head no. Why?
That's not a good face.
Which one?
The clients, if my clients look at me like that, I have explained to do.
All right. What someone said, sorry I tried. Sorry I tried. Right? Do you think it maybe got convicted? Somebody say that over here? Maybe the defendant got convicted and the lawyer's saying, hey man, I did my best. I did the best I could do. Okay? So somebody said maybe some good news, what would you think?
Relief after
All right, so maybe maybe that face is like, whew, we got by that one. Okay. So the people that were shaking their head no, and it's more like, hey, I did the best I can you see that perspective, that maybe it is that? Some yes? Could you see the other perspective? Okay, so you, what did you say?
I know that lawyer, so it's hard.
All right, so you can see that there's ways to interpret what you see, okay, in this case. But what I want to do is talk about this case a little bit, and then we're going to come back to the picture, okay? The defendant in this case was Robert Colley, okay, and that may ring a bell. And he was, his parents were murdered in a pretty brutal bludgeoning, both his mother and father. It would appear to be an apparent robbery case. 3 years later, Colley was arrested and charged with aggravated murder and with death penalty specifications. The mother-in-law retained the lawyer in the case for a civil matter, okay? It was not for the criminal case. He had appointed counsel in the murder case, okay? But the judge found out that the lawyer was involved in the case on this civil matter, and so he revoked the defendant's indigent status, removed his court-appointed counsel, and then designated this lawyer who was assisting on the civil issue, which had to do with insurance proceeds, okay? And he said to the lawyer, you're going to represent this defendant in this capital murder case, and by the way, the trial starts in 3 months. All right. Now, that's where I want to stop first. So, we talked about a prosecutor's issues in the first case. What about the judge's issues in these cases? What about the ethical considerations for judges? All right? Now, maybe there was a fraud being perpetrated on the court, and maybe this person wasn't indigent. And then I would say, and I would think you would agree, if that was the case, the judge would have every right to revoke that indigent status, or at least inquire further and then make a decision. All right, but what about you're going to represent this person on a death penalty case without co-counsel in 3 months? How many think that's fair? It's outrageous, right? This wasn't that long ago. So you're putting that defense attorney in an untenable situation. That's a lot of stress to be under on a capital murder case, no co-counsel. You weren't retained on that case, and the trial's in 90 days. And the judge has already told you, guess what? Don't ask me for what? A continuance, right? It's not happening. Now, judges are under pressure too. Judges are elected. Judges get endorsements from prosecutors. Judges have Supreme Court rules which require the reporting of stale docket cases. There's a lot of reasons why a judge might want to move along a case. But this is a capital murder case, and you just yanked the court-appointed lawyers off this case. And you put somebody on there that the defendant didn't hire to represent him in the murder case. So again, there's fault to go around when we look at these cases. But back to the story at hand. So at the time of the killing, the defendant was married, and his wife, after he was arrested, had moved down south. And she came back up because the defendant had proclaimed his innocence from the get-go. And again, there was no, this was a highly, highly, highly circumstantial case. There was no DNA evidence linking him to the crime at all. And his wife came up when she heard that this lawyer was appointed, quote-unquote, ordered to defend her husband. She came up from the south, and she started assisting, just kind of running errands, because she knew that this lawyer was working on this case by himself, and she believed in her husband's innocence. All right. Lo and behold, the wife and the defense lawyer get involved intimately 10 days before the trial. They start sleeping with each other. Okay? And this goes on throughout the trial, which lasted over 5 consecutive weeks. Okay? So the wife was working a lot of hours in the lawyer's office, helping the lawyer to prepare. They develop an attraction to each other. They become intimate. They pretty much become intimate every night during the initial start of this trial. The lawyer had a house out on a lake. They would go out to the lake. They would have sex. They'd come back. They'd work on the case. They'd have sex, this type of thing. All right, it's going on frequently throughout this case. 5-week trial. The defendant in the case is acquitted of the aggravated murder charges. He's convicted of lesser offenses of voluntary murder of the father, I believe, and non-capital murder of the mother. And he ended up getting, and he was also convicted of the robbery, I believe, and ended up getting 25 to life on the conviction. Okay? The lawyer never disclosed to his client that he was having an affair with the client's wife. This is the picture when the lawyer was convicted of the lesser offenses. Okay? So, does that change your perception of what you're looking at in this picture? What do you think those running through the lawyer's mind? What do you think? I mean, maybe it's the same. Maybe you're thinking, hey, I did the best I could. What else might you think? Yeah. I got your wife. Really sorry it's 25 years. Who knows? I don't know. I mean, that may be a very sincere photo. But now that you know the facts, it makes you wonder, well, did he really try as hard as he could? Did he really want to see this guy get acquitted and back with his wife? I don't know. So it brings us to this question, well, could he have tried his hardest? Could you try your hardest to acquit someone with whom you're having an affair with their wife? Can you do it? All right, so everybody thinks that'd be pretty tough, trying to step away from it. All right, let me ask you this question. Can you convince yourself that you did your best and that the affair had nothing to do with your performance? Yes, right? You can convince yourself of that, and you could do it pretty darn easily. Okay? Because what goes into that thought process? If you're the lawyer and you're in this situation, you know that what you're doing is not right. Okay? But what are you saying to yourself? I'm what? I'm sorry?
You can still do your job.
You could still do your job, all right? And what? I'm what? I'm a damn good lawyer, right? I've defended multiple death penalty cases, okay? And I was up all night, every night, for 3 months working this case. Well, and doing some other things, but... But you can see where you can convince yourself, even if you initially thought, you know what, I really need to say something about this. Because we're hardwired to suppress any thoughts that are internally in conflict with each other, which might call us to question our own integrity. So eventually, you just get to the point where, like, I did my best, and you start forgetting about the facts and about what happened, and you get to the point where, yeah, I'm good. No, I'm good. We're okay here. Huh? Here's some interesting facts. He was convicted in 98. He was convicted in 97, I believe. Let me just make sure of that. Yeah, 97. In 98, he told his own family that he was having an affair, which at that time was still going on, with the defendant's wife. Okay? But he didn't tell his client. And his client's case had gone up on direct appeal. So in 2002, his conviction was confirmed. 4 years earlier, the defendant had told his wife, his own wife, about the affair. But he didn't tell his client. Why? Separating personal and professional life? Why else? We talked about it a little.
I mean, that's just cruel.
There's no problem. He convinced himself that there was no problem. It didn't affect his performance. So I don't have to tell my client. By the way, he participated, as most trial counsel would, in the appeal. In other words, he cooperated with appellate counsel. But he never told appellate counsel, there was this little thing. Okay? He didn't do it. Because by that point in time, he had convinced himself that he had done everything possible in that client's defense and that his actions had no impact on the ultimate outcome of that case. Now, in January of 2011, okay, 14 years after the conviction, the defendant's sister tells the defendant that his ex-wife, they are now divorced, his ex-wife was having an affair with his trial lawyer. And what did the defendant say? He knew. He said, yeah, I knew. Okay? Defendant knew. But what he didn't know was when it started. He assumed that the affair started after he was convicted because the wife went to work full-time for the lawyer after that. And he assumed that they started an affair after that. He had no idea that the affair started before he was actually on trial, until his wife ended up telling him that the affair started before trial, lasted pretty much every night during trial and after trial. And then he told his lawyers, and his lawyers reached out to the lawyer that was representing him at trial that was having the affair, and they said, this is what our client's saying. And to the lawyer's credit, he said he's absolutely right. I did do that. And he cooperated, and he did an affidavit, and he maintained that in his mind, his actions did not impact that case. And he did not testify in the motion for a new trial. They just admitted the affidavit. But there was testimony at that time that he was given a list of, I think, 232 witnesses, only one of which had been interviewed. And so that, with that evidence, the judge granted the motion for a new trial, but the state opposed it. Okay, so again, you're like, there's so many opportunities here to do the right thing. The judge, the defense attorney, now the prosecutor. So the defense attorney comes to you and says, yeah, we just learned that the defendant's lawyer was having sex with his wife while he was representing him on death row. This guy wants a new trial. What should the response be? Okay. All right, I'm a minister of justice. That's not right. Okay, but the prosecutor said there's no evidence. They did admit the conflict. I mean, the lawyer said he did it. They admitted, yeah, we agree that there's a conflict. But you can't link up the fact that the conflict affected the outcome of the case. Okay? You can't do it. But the court said it's inherent. It's such a grave conflict, we're not even going to go there. Okay? So it went up on appeal. I'm sorry, the state then tried to file leave for appeal, and that was denied. All right? So clearly, the defendant, after the motion for a new trial, 7 to 14 years, I think by that time, 15 years had passed, and the prosecutor said, okay, you have your new trial? Well, what's the problem? So much time has passed. The defendant could get convicted again. So they worked out a deal, and the defendant ended up entering an Alford plea to voluntary manslaughter, and he got out of prison. So that's the end of the case for Mr. Cawley. But what about the lawyer? What about the judge? What about the prosecutor? Okay, well, the lawyer got disciplined. Someone filed a grievance against the lawyer. Actually, I take that back. The lawyer reported his misconduct. Now, we generally refer to that as a self-report. Okay, I personally don't think it is a self-report. I handled this case. A self-report, in my opinion, is when your conscience gets the better of you and you decide to do the right thing even though no one's telling you you better do it. I don't view a self-report as I got caught and this is really embarrassing, so I'm going to send my letter into disciplinary counsel. I don't view that as mitigating. Okay, but if the lawyer would have said in 2005 or 2002 and just come out and said, I did this, that would be a true self-report. But nonetheless, he reported it. And so we looked into it and, of course, did our investigation and deposed the respondent, the lawyer, and we prosecuted him. And the court hears every disciplinary case ultimately. They rule on every lawyer disciplinary case in Ohio. And they said, the sexual relationship intrudes into the marriage, subjects the client to double betrayal by the spouse and by the lawyer, destroys the trust essential to the relationship, erodes public confidence in the integrity of the legal profession, and undermines the lawyer's loyalty to the client. Okay? I mean, you hit all the words: betrayal, trust, loyalty, integrity. This was a major, major betrayal of a client's trust. Now, is this a wrongful conviction? What do you think? Yes? We don't know? We don't know? But think about it this way. I mean, does wrongful conviction mean you're innocent? Not necessarily. It means people took advantage of elements in the system, and the defendant ends up getting the short end of the stick because they weren't afforded all the rights that they deserved. In this case, the right to counsel. Okay? So the lawyer was suspended for 2 years with 1 year. So he lost his license for 1 full year. He now has his license back. It was a 6-1 decision. The Chief Justice, Justice O'Connor, dissented in that case and would have imposed an indefinite suspension, which is a minimum of 2 years, and then you have to petition to get your license back. So, here's a case where a lawyer was held accountable. Oh, I actually missed an important point from the last case. The 2 prosecutors, we prosecuted them in the disciplinary system, okay? And I handled that case as well. And as sometimes happened, things kind of fell apart during the trial a bit. And I have my reasons as to why that happened, which I won't share. But at any rate, what ended up happening is the prosecutors admitted that they violated the rule that prevents a lawyer from communicating directly with a represented person without the lawyer present. Okay, now we had charged them with other violations: conduct prejudicial to the administration of justice, dishonesty, deceit, misrepresentation, things like that, because they manufactured that whole, you call the lawyer and then have the lawyer call us and we'll pretend we don't know anything about the plea. But our witnesses, there were some issues. And so they ended up receiving reprimands, okay? And that's our lowest form of discipline. It's public, it's permanent, but it's a reprimand. You get to keep practicing, okay? But at the time, to be honest, I felt like at least we got something on it, because what's the reality in prosecutorial discipline cases? They're not out there. The numbers are astonishing. Some of them are in your book. They just don't, it just doesn't happen, okay? And it was important for us to salvage that case because we wanted to let people know that we're not afraid to take on a prosecutor. Obviously, we just like a prosecutor's case, we need the facts and we need the evidence. But I wanted to read you one part from that case. So, as often happens in these cases, lots of times you'll get into stipulations. And so when the trial comes down, if for whatever reason you don't have your victims or your witnesses, the lawyers will pretty much get to say what they want to say in mitigation, to tell the court, well, this is why this happened. And so that ended up happening in this case, and both attorneys had said that they were involved in that previous prosecution of the son in the murder case. And so this is what came out of it. The board also noted that no harm had come to Hatfield because of the respondent's misconduct, and found that the misconduct had occurred solely out of compassion for the mother, whose maternal distress caused the lawyer's distress, which in turn caused them to abandon their heads for their hearts. And, that's what they found. And that's what they testified to, was that we felt sorry for her. We didn't think, we did the end around because we thought, the lawyer wasn't going to be able to get this deal. And the one attorney was a mother, and she said it was a maternal instinct, a bonding of sorts. Okay? So that was a finding in the case. But I think what's important in that, even though we have that finding, is that there's still discipline. So sometimes, even with good intentions, whether you believe it or not, it's a finding. Even with good intentions, you should still be subject at times to prosecution when the stakes are so high like this. Okay? Okay, I got to speed up a little bit. All right, another case. FTI or an IOP, failure to report and impact on the profession. All right, this is a seminal case with reporting. And when I say reporting, I'm talking about lawyers reporting misconduct, which I think is part of one of the big problems when you get into wrongful conviction cases. People just don't take seriously their duty to report misconduct. And there's a whole bunch of reasons why, and all of them are legitimate. So in this particular case, there was a former district attorney whose name was Deegan. He meets up with his best friend whose name was Ruhlman. Ruhlman had been a former district attorney in the same office as Deegan. They meet out, they're best friends. They meet out for a drink. Deegan tells him during the meeting that literally that morning he was diagnosed with stage 4 colon cancer, and he only had a few weeks to live. During the same conversation, after a couple beers, Deegan tells him, hey, I need to tell you something. I suppressed exculpatory blood evidence in a case that I prosecuted and obtained a conviction. It was an armed robbery case. And the Ruhlman is shocked to learn of this disclosure. A, because he doesn't think his friend would ever do something like that. And B, because he's kind of shocked that he's unloading on him about this. And he tells him right then and there, I can't believe you did this. You got to make this right. You got to figure out how to fix this thing. And they have some more discussion about it. Deegan dies 3 months later. 5 years later, the defendant, whose blood evidence was suppressed, is set to be executed by lethal injection for an unrelated homicide that he's on trial for. Okay? The lawyer that's representing the defendant in the homicide case, okay, he's got a pretty good defense to this homicide, but what's he tell his client about testifying? You got a robbery conviction, right? You got this armed robbery conviction. You're not going anywhere near the stand. So he doesn't testify, okay? Ruhlman testifies, well, Ruhlman finds out from the news broadcasts and links up the fact that the guy that's awaiting lethal injection is the same defendant whom Deegan had told him 5 years earlier that he suppressed the blood evidence. Okay? So he puts two and two together, and he reaches out to the lawyer representing the defendant in the case. I'll just go back here for a second. So in that particular situation, the new lawyers come in, and they say, all right, we got this information that exculpatory blood evidence was suppressed on the armed robbery conviction. That affected our ability to defend this homicide. We got a case here. And that actually ends up working out in that the case is worked out for the defendant. And it was true that he did not commit the armed robbery and that there was evidence that was suppressed. So the issue then becomes, why did Ruhlman wait 5 years? Well, if we look at our duties, this is our model, our rule of professional conduct. The model rules, pretty much every state has some version of this, which reinforce the idea that we regulate our own profession. You and me, we're the regulators. Okay? A lawyer who possesses unprivileged knowledge of a violation of the Ohio rules of professional conduct, that raises a question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform a disciplinary authority empowered to investigate it. And then if you look at our advisory opinions in Ohio, not only do we have a duty to report other lawyers, we have a duty to report ourselves. The advisory opinion states it requires lawyers to report their own misconduct. Okay? So it requires you to examine your conscience and determine whether or not you have to make this report. All right, but what did he know? What did Ruhlman know after that conversation with Deegan? Well, if you look at what knowing means, it says a knowledge denotes an actual knowledge of the facts in question. Well, did he have actual knowledge? How many say yes? And that's going to be based upon the fact that the person that suppressed it told him, right? All right, but you could see someone can make the assumption that that's not actual knowledge. You're hearing it from someone who claims they did it, but you don't know it. Okay, so we'll give them the benefit of the doubt. But then it says, a person's knowledge may be inferred from circumstances. Now you're getting a little closer that he had this knowledge. So you apply this objective standard. Would a reasonable lawyer, under the circumstances, have formed a firm opinion that the conduct in question more likely than not occurred? All right. So you're Ruhlman. He's going to say, I didn't know. Okay? I can't remember if Deegan mentioned by name the defendant's name. Okay? And even Deegan wasn't sure that the suppressed evidence meant he was innocent. He just says he suppressed exculpatory evidence. Okay? But on the other hand, you could say, well, you had to know. Let's look at the circumstances. This guy gets a diagnosis of terminal colon cancer. I'm gone in a few weeks. And he lays this bomb on his best friend. And his best friend reacts not like, hey, let's have another beer, don't worry about it. He's shocked. and he tells him to fix it. So if he didn't think he did anything wrong, then he wouldn't have told him to fix it, and he wouldn't have been shocked. And then when the conduct got reported to the bar in Louisiana, the disciplinary authority in Louisiana, the respondent lawyer, Ruhlman, gave a statement. And he basically said, let me get it. I think it's interesting what he said and how they ended up using this. This is what he said when he was confronted with it. I think that under ordinary circumstances, I would have reported it. I really honestly think I'm a very good person. And I think I do the right thing whenever I'm given the opportunity to choose. This was unquestionably the most difficult time in my life. Deegan, who was like a brother to me, was dying. And that was, to say the least, distracting. That would be an understatement. I'd also left my wife just a few months before with 3 kids and was under the care of a psychiatrist taking antidepressants. My youngest son was then about 2 and had just recently undergone open heart surgery. I just had a lot on my plate at the time. A great deal of it by my own making, there's no question about it. But nonetheless, I was very, very distracted, and I simply did not give it the important consideration that it deserved. But it was a very trying time for me. And that's the only explanation I have, because otherwise I would have reported it immediately had I been in a better frame of mind. So when the trial came up, the disciplinary trial, about why he didn't report, his defense was, I didn't report because I didn't know enough. I didn't have to report. And so what ended up happening was the disciplinary authority ended up using this statement to the bar against him to say, well, you said that if you were thinking clearly, you would have reported it. And so they ended up finding that it was his duty to report, and that 5 years was too long to wait that long. Because there, if you notice back in 8.3, there's no time requirement. So when do you have to report? Most jurisdictions say that it's a prompt reporting. Now, people will call our office all the time with a situation, and they'll say, hey, can I run something by you? Do you think I need to report? And I usually turn it around and I say, what do you know? And then we go through what they know. And then they might get to the point where they say, like Ruhlman, I don't think I really knew. Okay? And then I say, that doesn't mean you can't report. That means you're not required to report. But you still can. And so one of the issues is, why don't we see more prosecutions from a disciplinary standpoint in these cases? Look at these headlines. The Guardian, The Watch, New York Times, Wall Street Journal, CNN. This stuff's all over the place. We're at a time now where the Innocence projects are in the news daily. But there's not a lot of disciplinary prosecutions. Well, I'm here to tell you that there's not a lot of reporting either. And sometimes the cases are they're hard because they're stale. Okay? So I think a big problem in the system, and going back to that first case with the 2 prosecutors, why wouldn't, all we needed was one of those 2 prosecutors to say, this just isn't right. And had that been done, it may have never gotten to the point there was anything to report. Or even after the fact, somebody said, this just wasn't right, and they report it. But instead, it falls on the defense attorney to report it. Okay, and you can guess where that relationship went. You can guess how many pleas he was getting for his clients after that. There's all sorts of reasons why people don't report, but we're a self-regulating agency. Sometimes it's the client. They don't want anything more to do with the case. They've lived this thing. You haven't. Okay, I don't want to have to go through this again and be re-victimized and testify again in a disciplinary proceeding. The lawyers, Defense attorneys, they know what happened. They don't want to report. Why? Well, who wants to rat on their colleague? I mean, it's not a fun thing to do to report someone. You probably wouldn't be surprised, but we get so many calls, people saying, in 42 years, I've never reported another lawyer. It's like, well, I'm sure you've seen a lot of stuff that would require reporting in your 42 years. But they don't want to do it because but for the grace of God go I. I've made mistakes. Other lawyers have made mistakes. I don't want to be the one to tattle on my friend. Or maybe it's even a little more selfish. I need pleas. I need to get good plea bargains from the prosecutor's office. If I'm the one that blows them in, I can kiss that goodbye. All right, and that's too bad if the prosecutor's office has that mentality, but it happens. How about the judges? The judges have knowledge of what's going on. We have a judge hotline as well. Get these calls all the time. Do I have to report? No, you don't have to, but you can. And eventually we might get around to, you can file something anonymously with our office and fulfill your duty. And we'll take it. I'd rather investigate an anonymous complaint than not have any complaint at all to look at. Election of judges. What judge wants to file against a prosecutor? Lots of times the judge and the prosecutor, especially in smaller counties, they're tied together. You need that prosecutor who's tough on crime. Because if the prosecutor's tough on crime and all the cases are getting tried in front of that judge, well, then the judge must be tough on crime. And when it comes time for election season, you're using endorsements. And that's a bigger problem. I mean, just the election of judges, it's not the best way. It's not the worst way. But certainly there are better ways out there to guard against some of these things. But the reality of it is it's just hard to report people. And then from our perspective, when we get cases in that are really old like this, we have proof problems with it. We can't just take a court of appeals decision that there was prosecutorial misconduct and apply that to a disciplinary case and say it's clear and convincing evidence that it happened. We got to prove the case. So that makes it difficult at times. And when clients come in with grievances, whether it's, for a wrongful conviction or just, poor performance by their lawyer, our office tells them, well, you have to raise that issue on appeal first. You raise that on appeal. If you're successful, come back to us. Well, that's going to deter people from filing. All right, but we're not going to investigate a case for an ineffective assistance of counsel or prosecutorial misconduct while it's pending in the system. We'll let that play out. And I'm sure some fall through the cracks then. So that's a weakness on our end of things. But at the end of the day, I think a lot of it gets back to a lawyer's duty to report. It's just not easy to do. The other thing, we talked a little about culture and mentality. Prosecutor's office, there's thousands of 2,000, 2,500 prosecutors' offices throughout our country. And some of them have excellent reputations. I'm sure that you could attest to the fact and enlighten me on the ones that that are going to be more open to requests from an Innocence project where there may have been a wrongful conviction. Some of them, the door's already closed, don't even bother knocking. Okay, there's reputations out there. As young lawyers, when we give CLEs to new lawyers, I tell them, your reputation is key. You got to know what you're getting into. You got to ask the difficult questions. Do you want to be part of this type of office? Because once you get in there, you're either on the team or you're not. And if you're not, you're gone. You either do the cases the way the boss wants them done, or you don't get the cases. And then your existence in that office is miserable because you're not happy, because you're not part of the group, you're not part of the team. But if you decide to take on that road, to take on that challenge, then you got to know that your reputation is at stake all the time. Because the minute you go to the dark side, Or you do something that you know you're not supposed to, that's it for your reputation. Good luck getting it back. So the more you're aware when you're younger, the better chance you have to steer clear of these situations in which you're put in where it's just really difficult and there's a lot of pressure on you to perform and to convict. Or from the defense side, not to tell my client about this issue. Okay? It's not just the prosecutors. The professional creeds we have, I'm not going to ask for a show of hands, but I bet over 3/4 of the people here have never even read them. Okay? They're kind of interesting. I mean, if we practice the way these creeds suggest that we're supposed to practice, we'd all have a lot more fun practicing law. But we don't. The Judge's Creed, the first quote, I know that I must not only be fair, but also give the appearance of being fair. That's not that easy to do. Everyone likes to think, well, judges are just automatically fair. They're human beings. And they have an incredibly tough job. They're subject to election. Who wants to lose their job? There's a lot that can compromise that. It takes a really strong person to remain fair and impartial. The next line is from the Lawyer's Creed. Act with complete honesty. Boy, would we have a different profession if we all abided by that, right? I mean, there probably a day doesn't go by where you know of a lawyer that you're interacting with that you do not trust because you do not think that lawyer is going to tell the truth. So there's a lot that we can do by ourselves to enhance the profession and enhance the public's confidence in the profession. And part of what you're doing is doing that, but it's after the fact. It's exposing some of these deep-seated problems in the profession, and it's creating awareness, and that's super important. But how do we get in front of it? How do we prevent this stuff from happening? And that's where I think we all have to look at our own conscience. We have to look at our own duties. What are we going to do for the profession? Am I going to make that report even though it's going to make me a pariah? Am I going to make that report if I know I'm going to lose a friend over it? It's not an easy thing to do. I can't stand up here and say I would do it. It's hard. But I think if we examine what we can do to help the profession and we just take those baby steps, we can make a big difference in how we collectively practice law. And I think we can really enhance the public's confidence in what we do as lawyers. So thank you guys very much. If any questions, I'm happy to answer them now, or if you want to ask any later.